Well, good morning, everybody, and a very warm welcome to all those who have joined us today. By way of introduction, I'm James Prothero, and I'm an associate in the Mills Reeve family team based in the Cambridge office. And I have the great pleasure of introducing to you this morning three other members of the firm's family department from across different offices. And we have, as we discuss the issue of family business assets within the context of divorce proceedings and how the court might deal with them. In cases involving a business, the arguments will often pivot on the correct treatment of business assets that were brought by both or one of the parties into the marriage. Rachel Brand, a senior associate in the firm's Cambridge office, and then Catherine Kennedy, a principal associate in the firm's Birmingham office, will consider different ways that the court will approach valuations of such businesses and highlight how wide the family court's discretion is in deciding how to share these types of assets fairly. Catherine will also present a brief case study from a case handled by Mills Reeve to put the issues raised in the course of the discussion into a wider context. Finally, Frances Bailey, a principal associate in the firm's Norwich office, will go on to discuss some ideas about how these family assets can be protected before and during a marriage, particularly with the deployment of carefully crafted marital agreements. But before all of that, I will briefly lay some foundations for our discussion by clarifying what the court is able to do when presented with an application for financial remedy from a party to divorce proceedings. Generally speaking, there are two stages of determining the division of finances on divorce. The first stage is to determine the extent of the party's assets, including any family business assets, after which the second stage of distributing the assets between the parties fairly can then be decided. Similarly, there are two stages to the court's approach to dividing the family's assets. First, the court must determine what orders it has the power to make in relation to the family's assets. And secondly, it must weigh the factors it is required to take into account when making such an order. So the various orders that the court can make are set out in sections 23 and 24 of the Matrimonial Causes Act of 1973. It can order a specific financial provision to be made from one party to the other, which would be a payment of spousal maintenance or child maintenance. It can also make an order for a property adjustment, including the transfer of a house from one party into the name of the other, a transfer of pension rights, and crucially for our discussion today, the transfer of shares in a business from one party to the other. So the court needs to weigh a number of factors when deciding which orders it should make under the powers given it in sections 23 and 24. Those factors are set out in section 25 of the Matrimonial Causes Act, and they include the parties' income, their earning capacity, each of their ages and health, but also crucially, the property and other financial resources available to the parties now and in the foreseeable future, and also the contributions made by each of the parties. And this final point regarding contributions is where the issue of non-matrimonial property would become relevant in a case. So what is non-matrimonial property? Briefly, the most succinct description for the purpose of our discussion can be taken from Baroness Hale's words in the combined appeal to the House of Lords in the case of Miller and Farland, who said that non-matrimonial property can include property brought into the marriage by one of the parties, and also property acquired during the marriage using funds received by either inheritance or gift. So the financial resources available and the contributions made by each party to the marriage are critical to the determination of any division of the family business assets, especially if those assets have been brought into the marriage by one party and have grown in value during the course of the marriage. These need to be weighed by the court, and in keeping with the discretionary approach of the family courts, it is for each judge to then decide whether to exercise its powers, and if so, in what manner. So in cases involving a family business, what to do with the assets of that business will often be the pivotal aspect of the case and be determinative of the financial outcome for the parties. So now that I've touched on what the court can do with such assets and the sorts of factors that it needs to weigh in making its decision, I'll now pass on to Rachel Brand to expand on more specific approaches the court can take to such businesses. So Rachel, over to you.
Thank you very much, James. So as James has already introduced, my name is Rachel Brand. I'm a senior associate primarily based in the Cambridge office, and I am a family law specialist. So James has already explained to us the type of order that the court can make, the court's considerations when considering division of assets on divorce, the stages in that process, and also, and very importantly, the discretion that the court has when considering finances on divorce. So as James has already outlined, one of the early considerations is what assets there are and whether there are any assets that should be treated as non-matrimonial. And James has explained the difference between marital property, which is acquired or built up during the marriage, and non-matrimonial property, which may be built up prior to the marriage or received during the marriage and kept separately. So if it's determined that there are non-matrimonial assets, and they've been kept separate and apart and not mingled with matrimonial assets, then there are two potential ways that these might be dealt with on division of finances on divorce. So one of those is that the non-matrimonial asset might not be included in the pot for division at all, unless that asset is required to meet needs. Or otherwise, it may be that it's taken into account, but when considering the overall fairness of the division between parties. So the focus of what I'm going to speak to you about today is really about what James has already outlined around what happens when a business has been built up, but not entirely during the marriage, which is actually often a very common factor, that someone has worked on a business and built it up ahead of meeting their future spouse. And in that situation, which part of that business would be treated as non-matrimonial? And how would you quantify and what that non-matrimonial element is? So what I'm going to do today is talk you through a couple of different approaches that the courts have taken to this issue. And also, I'm going to ask you what you think may be the preferred approach. So the first approach to have a look at in a bit more detail is the arithmetic or the linear approach. Really, this is a proportionate approach. It's looking at the length of the marriage compared to the life of the business. So it's considering what aspect of the business and how much of the business has been built up during the marriage, so marital property, and what was built up, say, prior to the marriage, so non-marital property. Well, whenever you have a slightly more formulaic approach like this, I suppose the positives or the advantages are that it can be quite a straightforward approach. It's relatively easy to calculate. It's formulaic, perhaps provides some certainty around what that valuation is going to be. But on the other side of that, a disadvantage or disadvantages of a more formulaic approach is that it's potentially quite arbitrary. And that may lead to it being potentially unfair because it may not take into account other circumstances. But what I would say is what James has already said previously is that all the circumstances are taken into account, and there may also be a cross-check against fairness. The other thing is that while we talk about a formulaic approach, that's not to say that there may not be some sort of adjustment for potential or a springboard effect and passive growth, which are all terms that Catherine's going to be talking about in more detail later on. So in reality, it may be that the formulaic approach isn't quite as formulaic as it's first set out to be. An example of this sort of approach being used by the court is in the case of Mr. Justice Mostyn, or the case of Martin and Martin, which is set out on your slides. So a very brief factual summary is that the husband started a business called Dextra in 1978. 8 years later, 8 years from the incorporation of the business, he started living with his future wife, and they married 11 years after the business had been incorporated and separated in 2015. So in this case, there are two quite interesting aspects of it. One is what happened with the valuation of the business, and the other is how non-matrimonial property was calculated. So firstly, in relation to the valuation, the evaluation has actually been acquired in relation to the value of the company at the time that the husband and wife started living together, which was in 1986. And in this situation, Mr. Justice Mostyn actually said that that value was not to be relied on and wasn't to be used on the grounds that it did not fairly and realistically reflect the company's potential. And he said that all decisions must be based on evidence and not confined to strict black letter accountancy. You might question the time and cost of actually obtaining this valuation when it wasn't even used by the court. But in reality, in other cases, it's not clear whether the court will require this evidence or not. However, given that some judges may require it, generally it's always better to get this valuation evidence than not have it at a future hearing. The other point I just wanted to raise here is around the fact that the valuation evidence had been obtained at the time that the parties started living together as opposed to when they were married. The relevance of that is that if there's seamless transition from cohabitation to marriage, then generally the period of cohabitation is taken into account in the length of the marriage. So what Mr. Justice Mostyn did is he took the value to be £221 million, which was very precisely the 85th percentile of the range of valuation evidence. So that is a very arbitrary approach to take there. So then what did he do to work out what aspect of this valuation was non-matrimonial? Well, he saw that the total life of the company was 39 years. That was from incorporation to the date of the hearing. And that the business had existed for 8 years before the parties had started to cohabit. So you can probably see where this is going. He looked at what percentage 8 years was of 39 years and came to the figure that this was roughly 20%. And therefore, he said that 20% of the company was pre-marital. As we all know, however, this is a rather arbitrary approach, given that companies don't tend to grow in a very linear way, and it may well be far more curved or a zigzag approach, and that also a day's work in 1986 may not be the same as a day's work in 2006. But Mostyn in this case said, I am firmly of the view that the correct approach to give effect to the sharing principle is to try and calculate the scale of the matrimonial property, and then normally to share that equally, leaving the non-matrimonial property untouched. The case was appealed, and this approach was appealed to the Court of Appeal. And interestingly, one of the judges in the Court of Appeal was Lord Justice Moylan, who we will see in a moment favours a slightly different approach to that of Mostyn. But even in this scenario, the Court of Appeal said that they supported the approach that Mr. Justice Mostyn had taken in the case, and that judges can determine what constitutes non-matrimonial property with such generality or particularity as they see fit, that they are not bound by a strict mathematical approach, and that the court has a very broad discretion. So in this case, actually the Court of Appeal said that Mr. Justice Mostyn's approach was not right or wrong. Actually, the linear approach was upheld in this case because it was the right approach in that case, but it may not be the right approach in all cases. So on the next slide, we then see the alternative approach, which is the intuitive approach. Broadly, this is taking into account fairness and all of the factors. It's not simply saying, let's take a proportionate linear approach. It's much more discretionary. And you could therefore say, we don't have the formulas, it takes into account more of the circumstances. A couple of examples of this are on the slide, which I will just speak about briefly. One of those is the case of Heart and Heart. This case was slightly different to the Martin case, because in the Martin case, there was one company which had been built up prior to the marriage and grown during the marriage. In the matter of Heart and Heart, the husband had actually had a number of different business ventures, and in the 1970s had moved into property development. And so it was more difficult to specifically say which aspects had been built up prior to and during the marriage. So the parties met in 1979, cohabited 4 years later, married a further 4 years later, and separated in 2006. This was a case where Lord Justice Moylan confirmed that the court is not required to adopt a formulaic approach, a bit like what he said in the Court of Appeal on Martin, and that a formulaic approach is not required to achieve consistency or to guarantee a fair outcome. And on the contrary, the case demonstrates the challenges which can arise when a court seeks to take a formulaic approach, where actually the financial history makes this difficult to achieve. And similarly, in the case of IX and IY, which is referred to here, Mr. Justice Williams noted, happily, recent decisions of the Court of Appeal in the field appear to suggest a less technical, more flexible, more common sense approach to such issues. So I mentioned at the outset that we were going to ask you what you think and what your preferred approach would be. So I am going to launch the poll now, where you will be asked which approach you prefer. So hopefully that will be appearing on your screens now. But just to summarize, so the linear approach, straight line apportionment, potentially more certainty, but also potentially a more arbitrary approach. The intuitive approach, on the other hand, more discretion-based, considers all factors, perhaps fairer, but perhaps doesn't have the same sort of certainty around it. So I will just give you a few minutes. We've had quite a lot of votes coming in already. So I'm just going to leave that for another few seconds and then share the results. Well, we're getting up to 80% who have voted, so thank you very much to everyone who has selected. And I am going to end the poll in just a couple of seconds. Thank you very much. So I'm going to end it now, and I'm going to share the results. Interesting results that we've got here. Hopefully you can see the results that have come up here. In fact, there is a huge amount of preference, 85%, for the intuitive approach over the linear and arithmetic approach. So you can obviously see there's an imbalance there. Some people prefer the more scientific approach, some people prefer the others. And I think whilst there's obviously a great deal of preference for the more discretionary approach, what can be seen is that not everyone agrees about it. The reality is that the approach taken regarding what's marital and what's non-marital depends on the facts. It depends on the circumstances of the case. For example, the Section 25 factors, but also the quality of the valuation evidence, how easy it is to apply a linear approach, and the other assets involved in terms of how risky they are. And we come back again to the court's discretion. The reality for us as advisors is that it can make it difficult to know what approach the court will take in these scenarios. And so I'm now going to hand over to Catherine, who's going to talk through some practical examples of the application of this, and then to Francis, who's going to talk about how to protect against this uncertainty.
Thanks very much, Rachel. Just by way of background, for those whom I have not had the pleasure of meeting either in the virtual world that we have been living in for such a long time now, or the real world, I am Birmingham based, and I sit on the subsector of the family team nationally dealing with businesses. Not, I hasten to add, because that's all I want to do. Actually, I quite like the breadth and variation family law offers. But actually, when I looked at what I did, and my cases, the majority do involve a business or many businesses. And so it seemed to make sense to me to use that experience both in my financial remedy practice and my mediation practice, and hence my involvement with the business team and presentation of this seminar. So I just wanted to reflect on the approaches that you've heard about from Rachel, and share with you just a couple of cases I've dealt with in practice that I think demonstrate those two different approaches. First is an example of what I view as a more mathematical, scientific Mostyn approach, and the details are sort of set out in summary on the screen for you. A 12-year marriage, husband in his early 50s, wife in his early 40s, 2 children, and overall assets are broadly about 5.6 million, and then some pensions as well. And the approach in relation to pensions wasn't particularly in dispute. We acted for the husband. He was a tech entrepreneur, one of these guys who has fingers in pies, had an established background in the automotive industry, and then developed software that could be used in that industry and others, actually, moving forwards. And he'd established already a number of companies selling internet services. So, you know, he had a background of experience in this area. A year before the parties lived together, actually whether they lived together was also in dispute. So, but the wife alleged they lived together for a period of time pre-marriage, and around about that time, the husband sort of formed the company. So we had an issue as to whether there was any value in this business at the point they allegedly started living together. Actually, our client said they never lived together. He met his mother-in-law, I think, on the day of the wedding for the first time, and in fact she hadn't even been aware of the marriage until a week before. So there was clearly a dispute of fact there between the parties, but nonetheless. And then around about the time they married, at that point the husband had established more of the corporate team for this business, They'd obtained contracts, a bit more developed at that point. And then 10 years into the marriage, the business was sold, or certainly a large proportion of it was. They did also retain a small shareholding, but the majority of the business, 85% of it, was sold, and for about 11.5 million. And husband received gross for his interest at that point, just north of 5 million. So the big issue 2 years post that company sale, when the parties separated, was how do we deal with the business? How do we deal with the wealth that's accumulated during this marriage as a consequence of a business that husband says was established pre-marriage, pre-living together, if they ever were living together, and wife says is a marital asset and should be shared, falls into the pot, for a 50-50 division. We approached a single joint expert, given that wife was seeking 50% of all of the assets, and husband was seeking to ring fence his premarital, what he regarded as a premarital contribution, arguing the business was pre-marriage. And then we looked at how we calculate the value of the business at those various different times. Interestingly, around the point of cohabitation, or alleged cohabitation, the turnover was quite modest in this business, about 15,000, with a profit of about 10. And then at the point of marriage, it was loss-making, but of course businesses that are very successful can be in their infancy loss-making. And in the financial year ending, so at the point of marriage it's loss-making, but at the end of that financial year, it had made again a small profit, about 20,000. So wife was, her case really was this business is worth nil, was producing a loss at the point of marriage. All the value's been accumulated during the marriage. It should be shared 50-50. Didn't have any value before that. And the husband's case was actually, that ignores all the effort that I put into this business. Before we even met, he would say, all the effort I put in then, and without all of that effort, the business would never have sold in the 10 years into the marriage for the value that it did. And the report looked very carefully at this. Clearly, that's what we're instructed to deal with, and assessed that at the point of the alleged cohabitation, it didn't have a value at all, in fact. But by the date of the marriage, a couple of years later, it did have a value, because by then there had been a product developed, intellectual property rights attached to it, customer contracts in place with big sort of blue chip firms. The expert took into account the fact that this was an established sort of team. They'd done business together before. They sort of all knew what they were doing. They worked in this area. They've got a good track record, and that there was actually a lot of potential, sort of a lot of latent potential in that business at the point of marriage, without which it would not have gone on to succeed in the way that it did. The valuer dismissed value in the business on an earnings basis. Actually, it was very limited income, if you remember the turnover figures, and used a discounted cash flow basis, looking at the estimated cash flow in the future, and was assisted actually in that exercise by our client being able to obtain sort of contemporaneous records, contemporaneous business forecasts that he had pre-marriage, literally rummaging around the attic in this case, finding that information. So that was taken into account, and the risk of those forecasts being slightly optimistic, because they were actually prepared for funding purposes and sought investment into their business at that stage. That was also taken into account, and the fact there was a small number of individuals and could be a risk with that. So the valuation took into account all those risks, but nonetheless came out with a valuation at the point of marriage of broadly 1.5 million. So whilst at first glance you might think that business was all established during the marriage, because what business is going to be worth 1.5 million with a turnover of 20,000? When you sort of delved down a little bit deeper and looked into all the background and everything that had gone on to get to that point, it was recognised that actually that business had a huge value already. And then there was passive growth taken into account. So, you know, what element of that value was achieved without any further effort or activity? What was achieved just because of that value at the point of marriage? And that was estimated at broadly 500,000. So as a consequence of that, it's helpful for us, of course, that we argued, well, the husband should really retain his premarital element to the company. We know what it is now, together with passive growth. We know what that is as well. We'll ring fence that for the benefit of the husband, and everything else, the marital pot, can be divided equally. And in terms of outcome, it broadly was a division of 60-40 to the husband. And you might think, well, gosh, it's a lot of effort to go to for a departure from equality of 10%, which we see a lot, of course, 60-40 outcomes. But actually, when you think that's, an extra, over $1 million extra for the client, 1.2 million, it's a really important factor to take into account, really important to look at this premarital value, very important evidence. So huge benefit to the husband there in establishing the value of business at the date of marriage, arguing passive growth on top of that, and looking at a very, very strict mathematical approach. It's to his advantage. And then, pensions were shared equally, and they put some funds aside for school fees. So that was an example of the Mostyn approach. Perhaps if I move on now to have a look at the other approach, it was more of a broad attempt to seek fairness, as per Section 25 of the Matrimonial Causes Act that you heard about earlier from James, the Moylan approach that Rachel spoke about. And again, the facts of that case are set out on the screen. Short marriage in this case, only 5 years. Wife in her 40s, husband in his 50s, with 2 children from the marriage, and they also had children, each of them from previous relationships. It was a wife in this case who was the company director, and she had a third shareholding in a family business that had been established in the 70s. And she'd received 60% of her 1/3 shareholding before she'd even met her husband, and the remainder when they met at the point of the sort of commencement of the relationship. She received the remainder. So she had a third shareholding in this business. And the other shareholders were family members, and she worked in the business. She did very well in it and contributed a lot to its growth during the course of the marriage, in fact. Otherwise, the assets were quite limited. There was a family home, which had limited equity, and there were some pensions. The husband had a pension, and the wife had a smaller pension, and there was a pension sharing report obtained. But the big argument really centred on the company. And the husband sought a share of it, or capital in lieu. And the parties had obtained an expert report, an SJ report, which broadly attributed a value of circa 800 to 900,000 to the wife's value in the business. Actually, this case we became involved in quite late in the day. So the parties had already had an FTA, first directions appointment. They'd already had a financial dispute resolution hearing, a negotiation hearing, and the wife had dealt with all of that in person really quite well, I think. But post that, with the risk of a final hearing, she engaged lawyers. And so we might have addressed this case in a slightly different issue if we'd been involved earlier. We'd have been able to be involved in the SJ instruction perhaps a little bit more, ask the right sorts of questions. So we had to revisit that report a little bit. The historical valuation at the outset of the marriage hadn't been adjusted for inflation, for example. There were big figures appearing in that report, and I think the problem was this husband had seen the big figures and couldn't refocus himself as to sort of net effect or the nature of those assets. He was intent on sort of maximising his claim, really. There hadn't actually been any consideration in the report of this sort of passive growth. Well, what value of this business accrued during the marriage is because of everything that went before it, established in the 70s. This sort of springboard effect we talk about. The fact that there was always huge value in this business already. which was nothing to do with our client, although she did well when she was involved in it. So there'd been very, very little consideration of that in the report, actually. And also, we had to look at things like the Articles of Association, which actually provided that the shares should stay only with people who work in the business. Very much a family business, they wanted to keep it in the family. This was very important. Because remember, we often have clients who think that the business is excluded or it doesn't form a marital asset. It's surprising how that view still prevails. But the court has the ability to transfer shares in businesses. It's not that often done, obviously, because everybody wants their clean break, and it can be very difficult to stay involved in businesses together. But in this case, actually, 2 days before the final hearing, husband asked for a share transfer. He said, well, if you can't give me my lump sum that I seek, I'll have a 45% shareholding in the business, please, of her interest, 45% of her interest in the business. I'll take the shares. Which it's a very acrimonious case, would have been really an outcome that the client couldn't have tolerated at all. It would have been awful. So what happened in this case in terms of judgment? I think this is another example of a judge sort of doing the right thing. I would say that when you hear the outcome, you'll understand why I would say that, because it worked for our client. But there we are. It was a short marriage, so that was a factor that was taken into account. I'm certain of that. So the court was willing to interpret the husband's needs perhaps in a slightly less generous way as a consequence. And the court was also very prepared to look at the non-marital bequest, to sort of bear that in mind, that a non-marital asset, which this business may be viewed as in part, although it's been used to sustain the family economy to an extent in terms of the income, doesn't really change the asset of the nature of that non-marital asset. And again, because this business it was in the family since the 70s, and it was effectively inherited, really, that it was an inherited asset. So, again, that sort of steered the court in this case, this judge, towards more of a needs-based award rather than a sharing award, which is what the husband was seeking, full share. It was established as a quasi-partnership. We had argued there shouldn't be, but we knew that was always going to be established. So the court went with that, and the court also gave great weight actually to what the other directors had to say. Notwithstanding they were family members, the court heard evidence from them, and actually decided they were quite reliable witnesses, quite fair witnesses. And they confirmed in evidence in court that they wouldn't allow shares to be held by someone not working the business. They didn't want to increase the earnings in this business. They wanted to keep money in the business. It was working capital. It was required. That's how it's always been used. The liquidity in the business, which was attributed by the SJE at I think about £1 million from memory, was all based on borrowing. They'd never borrowed. They didn't want to borrow. That's not the way this business worked. And the judge took that into account and accepted that was historically how it had been dealt with. The judge was also actually quite concerned that when the expert gave their evidence, they didn't seem to have much knowledge of notions such as springboarding or passive growth, the Jones and Joe sort of argument, that actually, the value of the business that had accrued during this short marriage was only there because of everything that came before it. That was the springboard. The judge was a bit worried that the expert in this case didn't really grasp those issues in great detail in the report or on cross-examination. And the judge really approached it in the end by saying, the majority of this business is a non-marital asset. We're going to look at need, and that's what I'm focusing on. And yes, wife will have to pay a lump sum, which inevitably was going to have to come probably from the business. She didn't have any liquid assets other than that. But the lump sum was limited to 133,000. And just very quickly, a point of interest there is that as soon as the client had come to Mills Reeve post her negotiation hearing, she was faced with a final hearing. Pretty much the first thing we did after assessing the case was make an open proposal to try and do a deal on this. And she didn't want to go to a final hearing. had no ambition to do that. She didn't want a day in court. She didn't want the costs, quite understandably. And she made a proposal of 100,000 to the husband. That was 7 months before the final hearing. And he rejected it. I can't remember if he responded to it, to be honest, but he certainly didn't accept it. And in the meantime, his costs escalated. By the time of the final hearing, he owed 90,000 in legal fees, something like that. His legal fees were 100,000 at least. So when an award of 130,000 was made, in reality, what he got was incredibly limited. And if he had engaged sensibly with negotiations, very early on, that just would not have happened. So I think, again, it's a flag for the importance of being realistic, engaging in negotiations. He was heavily criticised by the judge. The husband in this case said he wanted a final hearing, wanted a judge to decide, because that was a fair way of dealing it, let the judge decide. And the judge actually was hugely critical of that approach. No, it's not for a judge to decide. Really, you've got to take ownership of this yourself. You've got to engage. You've got to be sensible. So I think that was a really interesting point, actually. I think that the presence of that open proposal in the bundle helped as well. So that's really an example of the broader attempt courts will undertake to seek fairness, the Moylan approach, consideration of all factors. So just quickly to summarise, then, we've seen, the approach generally is matrimonial assets are shared, and businesses can be regarded as matrimonial assets, despite what many clients sometimes think, but non-matrimonial nature of the assets will be ring-fenced unless it's required for need. Valuations, you've heard about the arithmetic and intuitive approach, both valid. You've heard that we can get expert evidence and ignore it, just go for the feel of it. We can get no expert evidence. Some cases, the judge completely ignores any expert valuations. I can tell you, for one, I would never go to a final hearing without expert evidence. I think that was a bit of a risk. And then when you do get expert evidence, you really, if you're acting for the business owner, you really need to look at those premarital values, strip it out, look at springboarding, look at passive growth, uplifts, all those sorts of things. So I'll just hand over to Fran now, who's going to talk about some preemptive steps you might be able to take to stop those sorts of arguments happening in the first place, to protect businesses.
Thank you very much, Catherine. So for those of you who don't know me, I'm Frances Bailey. I'm a principal associate, primarily based out of the Norwich office, to the extent that geography has any relevance in this new world we find ourselves in. So like all the other speakers on this call, I have a particular interest in business assets on divorce and dealing with financial remedy cases for business owners. But I also have a particular interest and specialism in pre and post marital agreements, and effectively, as Catherine said, trying to inject some certainty into what, as you've seen from this talk, is a very uncertain discretionary system. So firstly, what do I mean by a marital agreement? I mean a pre or post marital agreement, which is an agreement entered into either before the marriage or during the marriage, but during happier times, which seeks to set down a party's agreement as to what they would want to happen to their assets in the event of a hypothetical separation. And in that respect, it's very different from an agreement reached post that separation occurring, which can either be embodied in a separation agreement or a consent order. And the kind of key distinction there is that a pre or post marital agreement is very much dealing with known unknowns. No one actually knows what the financial personal circumstances of the parties will be at the point of separation, whereas a separation agreement or consent order is obviously dealing with a crystallized situation. In that respect, is both much easier to negotiate in many ways, and also has throughout time been regarded as a sensible exercise as party autonomy, whereas historically there's been a real kind of public policy against premarital agreements, as it was seen that they encouraged relationship breakdown in some way. However, things have moved on, and that kind of public policy objection is now no longer seen as valid. So what is their legal status? The current situation is that Parliament has not legislated to bring into force binding pre or post-marital agreements, or nuptial agreements as they're sometimes called. That's despite various calls for reform, most recently in 2014 by the Law Commission, who recommended the introduction of a nuptial agreements bill that would provide for binding agreements that could only ever be overridden to the extent to meet needs. And in place of Parliament legislating for them, what's had to happen is that the judiciary have really taken this issue and run with it. And in a series of cases, starting from very much the early 2000s and culminating in the 2010 decision of Radmacher and Granatino, which went all the way to the Supreme Court, and many of you will be familiar with, they have given increasing weight to party autonomy when exercising that discretionary exercise under Section 25 of the Matrimonial Causes Act that James spoke about at the commencement of this talk. The quote from Radmacher and Granatino, which effectively encapsulates the law as it stands now, is set out in your slides. I'm not going to read it to you, but the effect of it is that we can say with some degree of certainty, but there's no guarantee, that a nuptial agreement or a marital agreement should be determinative of parties' claims, provided that certain procedural safeguards are met and provided it is quote unquote substantively fair. Those procedural safeguards, very briefly, are that it should both parties should have the benefit of legal advice. They need to know what their potential claims are and understand those to understand the effect of the agreement. Equally, to enable them to kind of contextualise that advice, there needs to be financial disclosure so that each knows what the other person's assets are that they are potentially giving up a claim to. In the case of a premarital agreement, it shouldn't be entered into in the 28-day period ending with the wedding, so as to avoid any argument about undue pressure, etc. And then there's certain kind of provisions about the form it should take, so it should be by way of a deed and it shouldn't be void for contractual principles. Substantive fairness is a little bit harder. Fairness is very much in the eye of the beholder, but generally it's been interpreted in the case law post Radmacher as meaning that an agreement shouldn't leave a party in a position of need, albeit need is likewise a very subjective concept. So moving on, what does this look like for business owners? What might they seek to do in a premarital agreement? So commonly they take one of two forms. They can be kind of high level in principle documents that might, for instance, set out certain assets that would be ring fenced from a claim, or commonly say premarital assets, inheritances, etc., but don't seek to actually determine the division of the other marital assets. Or it can be a much more specific document that seeks to do a lot more crystal ball gazing and sets down quite specific provision, typically to meet needs such as housing, school fees, maintenance, etc. Maintenance may, of course, be capitalised. One area that they can be particularly useful, actually, for business owners in particular, is the schedules of disclosure that are typically annexed to the back of the document. Now, those will be relatively detailed, although nowhere near the detail you would expect to have to give in the event of a relationship breakdown, but they can be used to set out an agreed value for the premarital business that a business owner is bringing into that relationship. And the case on your slide, a case of AC and DC, is a really good example of that. It's actually in that case the husband conceded very early on that the wife shouldn't be held to the terms of the premarital agreement because she'd entered into it without legal advice. But it was still a very helpful document for him. In very summary terms, the total pot of assets was circa 38 million, of which over 35 million was represented by the husband's shares in a company that was called DH in the judgment. He had nearly 85% shareholding in that company. The premarital agreement was really useful because it set out an agreed figure for the value of his shares of £4 million as at the date that agreement had been entered into. And what the judge dealing with the case did was say that £4 million I'm going to ring fence. In addition, I'm going to allow another £4 million of passive growth, which Catherine's already explored as a concept, and therefore the husband was able to ring fence effectively £8 million from the wife's sharing claim, leaving a matrimonial pot, as it were, of £30 million for division between them. I wanted to talk very briefly, because I'm conscious of time, about other wealth protection considerations. It is my view that premarital agreements, postmarital agreements work best as part of just one part of an armoury of wealth protection documents. So one of the circumstances we often see people coming to us for advice on in relation to premarital agreements is where they have inherited a multi-generational business, or they stand to inherit shares in a multi-generational business. Now, for the older generations seeking to kind of cascade those shares down through the generations, they might want to insist upon premarital agreements for the future generations before they receive their shares, but they might also want to look at trust structures, and our private client department can help with those. Equally, some of the families we deal with have family constitutions, which provide a much kind of broader regime for the operation of the family wealth. And we also often work with our corporate department in terms of reviewing corporate documentation to effectively divorce-proof as much as possible a business. And Catherine alluded in her talk to some really useful provisions, I think, that were in the Articles of Association of one of the businesses, and also useful evidence given by the other shareholder directors, which was vital in that case. And finally, before I move on, just a word about dispute resolution. Catherine's mentioned that the husband in the second case study she talked about really didn't want to kind of engage with taking responsibility, as it were, for the resolution of his own claims, and was criticised by a judge for that. The court is a very blunt tool, and it should be regarded as a tool of last resort. It's my view, and a view I think is shared by all of the speakers in this talk, that dispute resolution is a much better option for people, and that can cover a whole kind of range of processes, ranging from parties sitting down around a kitchen table, having taken advice, of course, as to what their claims may be, through to mediation, which may or may not be with lawyers present, depending on complexity, collaborative law, traditional roundtable meetings, and arbitration if a third party assistance is required. The benefit of those options is they're much more bespoke. So, for example, with a business, it can be quite common to adopt more of a multidisciplinary approach and involve the party's accountants or the company accountant, financial advisors, etc., in those discussions, so that a kind of holistic, tax efficient and commercially efficient solution can be found that is fair in the eyes of the family court as well. And on that note, we had a very useful comment pre-talk from David Green, who mentioned his common experience with business owners being that they are very used to kind of strict budgeting and cost benefit decisions when running their businesses, and suddenly they're faced with divorce, which can sometimes be seen as somewhat of a blank check for the family lawyers. Those dispute resolution mechanisms in particular kind of really lend themselves to parties sitting down very early on and working out the kind of the cost of the process and what it might look like, and being able to factor that in a commercial way into their negotiations. I wanted to talk very briefly about the resources we have available. Both of our microsites appear on the previous slide, thank you. And in addition, we've written a number of books. Nick Stone, who heads up the family law team nationally, has written a book about businesses on divorce, which I couldn't lay my hands on earlier, but we have also very recently, and I am waving in front of the camera, written a book about family agreements, which is available in electronic copy. So if anyone wants to link in with any of the speakers, we can get that out to you. So moving on, we have some Q&A if people want to stay on the call. So we have a Q&A that's just popped in saying, discretionary trust, if a beneficiary inherits an asset pre-marriage, will marriage breakdown affect such asset? So in very summary terms, the asset would be taken into account as a resource, but its pre-marital nature, particularly if it's come through a trust structure, would be of the utmost relevance, and provided needs have been met, could be met from the marital resources, it is quite likely that resource would be remain with the party you inherited it, which I hope answers your question. We also had some questions for Rachel and Catherine. I don't know who wants to take this one, but one of the attendees asked whether or not, in our view, the Moylan broad brush approach or the Mostyn linear approach is the right one. So I don't know who wants to take that.
Well, I mean, it's just a matter of opinion, isn't it? I really see why people want certainty in these sorts of disputes. I do understand that, but I actually think every case rests on its own facts, and they're so different that I'm with the majority of people who voted earlier in the poll, actually, and I think overall I prefer the discretionary approach, or the factors of the case. I think that leads to fairer outcomes. That's my personal opinion.
Yeah, I think I agree with you, Catherine. There's a second question, which either you or Rachel might also want to address, which is in relation to valuations. Given that some judges seem to adopt much more of an intuitive approach, or simply kind of not take into account valuations at all, and I think you already touched on this in your talk, Catherine, do you think in practice it is essential to get a single joint expert report about premarital value?
I do. It's a straight answer to that. Yeah, I think you would be taking enormous risk on behalf of your client if you decided to, end up at a final hearing without that evidence. Notwithstanding that judges sometimes do completely ignore it. It's very frustrating, but it has to be proportional, doesn't it, as well? But yes, on the whole, I wouldn't want to pitch up a final hearing without evidence. And actually, it can be very helpful in negotiations as well to have that early on.
Brilliant. Thank you. And then there was one question on premarital agreements, which was about what evidence people should get of a value of a business for a premarital agreement. Again, it will probably depend upon the resources and cost concerns of the clients. I wouldn't necessarily be advocating that you need to go and get a single joint expert valuation, but a letter perhaps from the company accountants with a valuation mechanism, which can then effectively be determinative of any subsequent valuation to assess what then the marital growth is, can be quite useful. And one thing that's actually really interesting here is clients often think they need a low valuation, whereas actually conversely for a pre or post-marital agreement, you're probably looking for a high valuation so that you are setting the starting bar of kind of growth high, and then at the end of the relationship you're looking for a lower valuation at that stage. So I think, unless anything else has popped into the Q&A, that winds up all of the questions we've been asked. When you come off the seminar, I understand a survey screen will come up. If you could all take a couple of minutes just to fill that in, we'd be really grateful. We'd like to hear about what other topics you might want to hear from us. And I, on behalf of all my panelists, say thank you very much for joining us. We hope you have a good rest of Tuesday.